You could lose access to your beautiful children, not because you're a bad parent, but because the system isn't about fairness. It's built to protect procedure. Most parents walk into family court thinking love and truth will protect them. But one wrong move, one careless signature, can change your child's life forever. Custody agreements aren't designed for justice, they're designed for efficiency. And if you don't understand what's hidden inside those pages, you're walking straight into a legal trap. I know this is hard to hear, but most parents lose custody not from neglect, but from ignorance. They trusted the process, signed too fast, or believed joint custody meant equal time. It doesn't. That's why today, I'm exposing the 5 biggest custody agreement mistakes parents make and how to avoid them, the same ones that quietly destroy families every single day. Because if you think your custody agreement protects your kids, think again. If you're going through divorce or custody stress right now, hit subscribe, because I break down the hidden truths they don't teach you in court, every single week. Mistake 1: believing joint custody means equal time. Here's the shocking truth most parents never see coming. Joint custody does not mean 50-50 time with your kids. It sounds equal. It sounds fair. But in the courtroom, joint is just a label, and that label can be dangerously misleading. According to the American Bar Association, joint custody can simply mean joint legal decision-making, meaning both parents share authority over major decisions like schooling, healthcare, and religion. But legal custody and physical custody are two completely different things, and that's where most parents get blindsided. Because in reality, you can have joint custody on paper while your ex gets most of the parenting time. That's right, the court can give both of you decision-making rights but still assign one parent as the primary custodian. The other parent? Reduced to weekends, holidays, and a few scattered days that vanish faster than you realize. And here's the part nobody tells you: courts don't actually aim for fairness, they aim for stability. The court's job isn't to divide time equally, it's to decide what feels least disruptive for the child. So if your ex happens to live closer to the child's school, or has a 9-to-5 job that looks consistent on paper, the judge might view them as the more stable parent. Even if you're just as loving, even if you've been the one doing the hard work, packing lunches, attending doctor's appointments, helping with homework, none of that automatically guarantees equal time. Many parents only discover this after signing their custody agreements. They think they've won shared custody and breathe a sigh of relief, until they realize that shared actually means shared decisions, not shared days. By then, it's too late. The schedule is already locked in. And trying to modify it later? That's like trying to unring a bell. Courts rarely change custody unless there's been a significant change in circumstances, and proving that is an uphill battle. That's why you must read every word of your custody agreement. Don't just trust the title, inspect the schedule. Ask specific questions. 1. How many overnights do I get per month? 2. What happens during holidays or school breaks? 3. If our schedules change, how do we modify this? Because until it's written in clear, black and white language, the system will interpret it however it wants. Remember, the word joint is not a promise. It's a placeholder, and it only protects you if the details back it up. So don't get fooled by the label. Don't assume that a fancy title like joint custody means equality. In family law, titles protect lawyers, details protect parents. Read, question, and document everything. Because once the ink dries, those few lines of text decide not just your custody arrangement, but how much of your child's life you'll actually get to live. And if you think that's misleading, wait until you hear mistake 2, because this next one can make you lose custody even if you're the better parent. Mistake 2: ignoring the power of documentation. You can be the most loving, stable, responsible parent in the world, but if you can't prove it on paper, the court won't care. That's the brutal truth about custody battles. Family court runs on evidence, not emotion. The judge doesn't see your daily sacrifices, your bedtime stories, your sleepless nights when your child was sick. They only see what's written, recorded, and submitted as evidence. And here's where most parents lose. They rely on emotion, on the hope that their sincerity will shine through, while the other parent quietly builds a mountain of documentation that makes them look like the organized, responsible one. It's not about who's better, it's about who can prove it. According to the National Family Court Review, parents who maintain organized communication logs, documenting calls, texts, visitations, and school involvement, are significantly more likely to receive favorable custody rulings. Why? Because documentation builds credibility. And credibility wins cases. When you walk into that courtroom, every single thing you say is measured against what you can prove. Judges have seen thousands of parents claim to be the more stable one. So your word alone won't move them, but a detailed, dated record will. That means starting now, not later. Create a custody journal. Record every visitation. Log every missed pickup or late return. Keep screenshots of communication that shows your effort, whether it's emails about school updates or texts where you're trying to coordinate schedules. If your ex cancels visits, note it down. If they violate court orders, document it immediately. If you attend parent-teacher conferences, keep the email invite or take a photo of the sign-in sheet. Every detail matters. Because when accusations start flying, and they will, your documentation becomes your defense. Without it, you're just another story in a courtroom full of stories. Now, here's something most lawyers don't tell you: judges can smell emotional chaos. They can see when a parent's frustration starts controlling their actions: angry texts, impulsive calls, social media rants. That's why you must document everything calmly and factually. Keep emotion out of it. Think like an investigator, not a victim. You're not building a diary. You're building a record of reliability. And trust me, the parent who documents wins in the long run. Because when the court asks, how do we know who's telling the truth, the answer will come from the paper trail. Even if your ex lies or exaggerates, the one with consistent evidence comes out on top. It's not fair, but it's the system. So no, documentation isn't paranoia. It's protection. It's how you make your truth visible in a place that only believes what it can verify. Start now. Write it. Date it. Save it. Because one day, those notes, screenshots, and emails might be the difference between being the weekend parent, or being the one who tucks your child in every night. But if you think that's intense, wait until you hear mistake number 3, because most parents make this one without even realizing they're breaking the law. If you want a free checklist of what to document during custody disputes, comment "I want" down below and I'll have it sent to you. It's the same list divorce coaches give their private clients. Mistake 3: withholding visitation out of emotion. Let's be honest, when your ex crosses the line, breaks promises, or puts your child in a situation you don't agree with, every instinct in your body screams one thing: I'm not letting my kid go back there. And as a parent, that emotion makes perfect sense. You're not being controlling, you're being protective. You're trying to shield your child from harm, confusion, or instability. But here's the painful truth: in the eyes of the court, that protective instinct can look like defiance. Under most state family codes, denying visitation without a court-approved reason is considered custodial interference, a serious violation. Judges see it as one parent taking the law into their own hands, and it can lead to contempt of court, fines, or even loss of custody rights. Even if your heart is in the right place, the court system only respects procedure, not emotion. Let's break that down. If you stop visitation because your ex was late, rude, or even irresponsible, the court doesn't see your reasoning, it sees a pattern: parent A denied parent B access to the child. That alone can shift how the court perceives your stability and cooperation, two key factors in every custody ruling. And it gets worse: once a judge sees you as uncooperative, every future motion you file comes under suspicion. They'll question your motives, your judgment, even your credibility. Suddenly, you become the problem parent, not because you were wrong, but because you acted without the court's permission. Now, does that mean you should ignore red flags or dangerous behavior from your ex? Absolutely not. But there's a right way to handle it. If you believe your child's safety is at risk, physical, emotional, or otherwise, you file an emergency motion or a petition to modify custody. That's the official channel. You present evidence, not emotion, and let the court authorize changes. And here's where documentation from mistake 2 becomes your secret weapon. If you've been keeping records, missed pickups, erratic behavior, unsafe environments, that documentation gives your concerns weight. It tells the court you're not being spiteful, you're being factual. On the other hand, if you simply withhold your child, even for what feels like a good reason, your ex's lawyer will use it against you instantly. They'll paint you as vindictive, controlling, or emotionally unstable, and the court will listen. You could lose parenting time. You could lose decision-making rights. You could even lose custody altogether. And it happens every single day, not because the parent didn't care, but because they didn't know the rules. So, if your ex breaks agreements, don't react, respond. 1. Document every incident. 2. Contact your attorney immediately. 3. File the proper motion. 4. Protect your child within the system, not outside it. Because here's the ugly truth, the parent who keeps calm and follows procedure, even when their heart is breaking, usually wins in the long run. The court respects control, not chaos. So never let your emotions write your custody story. Protect your child, yes, but protect your case first. Because the moment you act out of anger or fear, you hand your ex the very evidence they need to take more from you. And if you think losing visitation time is bad, wait until you hear mistake 4, because this one doesn't just threaten your custody. It can drain your bank account and destroy your financial stability in one blow. Mistake 4. Overlooking financial responsibilities in custody deals. Here's where most people, especially fathers, unknowingly walk straight into a trap that can haunt them for years. See, when you're in the middle of a custody battle, your attention naturally goes to the emotional side. How much time will I get with my kids? What does joint custody actually mean? Will my ex try to turn them against me? But what your lawyer may not stress enough is this: custody and child support are not two separate worlds, they're tightly connected. In fact, every payment you make, or fail to make, tells a story to the court about what kind of parent you are. If you fall behind on child support, even by accident, it doesn't just show up as unpaid debt. It becomes a legal weapon that can be used against you. The U.S. Office of Child Support Enforcement makes it clear, missed or inconsistent payments can be presented as evidence of instability or non-compliance in future custody hearings. Think about that, your entire credibility as a responsible parent could collapse over a single financial oversight. Maybe you lost your job for a few months. Maybe your ex didn't tell you about a medical bill. Maybe you thought you'd catch up next month. But to the court, it looks like neglect. It looks like unreliability. And here's the painful reality: once a custody or support agreement is signed and filed, it's incredibly hard to change. Courts rarely modify these orders unless there's a major, documented shift in your circumstances, like losing your job or suffering a health crisis. Even then, the process is long, expensive, and emotionally draining. That's why before signing anything, you need absolute clarity on what your financial responsibilities include, and what they don't. Don't assume child support automatically covers school fees, summer camps, or extracurricular activities. It often doesn't. Those things can easily turn into new points of conflict later, with one parent claiming the other isn't contributing their share. Make sure every expense is spelled out in the agreement. 1. Who pays for medical insurance? 2. How are copays or emergencies split? 3. What about private school tuition, after-school programs, or travel costs for visitation? Every detail matters, because once that ink dries, the court expects you to follow it exactly as written. There's no, "I didn't know," or "I thought that was included." And when financial misunderstandings start piling up, resentment builds, and suddenly your ex has ammunition to challenge your custody rights. You might be portrayed as careless, irresponsible, or worse, unfit to handle the kid's needs. So don't just sign. Study. Ask. Clarify. Negotiate. Get a financial expert involved if you have to. Because overlooking a single line in your custody deal could cost you not only money, but precious time with your children. But the final mistake? It's the silent killer of custody cases, and almost nobody talks about it. And if you're serious about protecting your kids and your peace of mind, make sure you hit that like button. It tells YouTube this is information parents desperately need to see. Mistake 5. Failing to manage your emotional triggers. Here's the truth no one tells you: custody battles are rarely won on paperwork alone, they're won in composure. Because a custody battle isn't just a legal war. It's an emotional one. It tests every part of you, your patience, your pride, your sanity. You're not just fighting for time with your child, you're fighting through betrayal, fear, and the deep ache of uncertainty. But the moment you let those emotions spill over, the court stops seeing you as a loving parent, and starts seeing you as a liability. Judges may not say it out loud, but they watch everything. The tone of your voice. The look on your face. How you respond when your ex or their lawyer pushes your buttons. Every sigh, every sarcastic remark, every angry glance, it all builds a picture of who you are under pressure. And in custody court, perception is power. The American Psychological Association actually confirms this. Emotional regulation during custody disputes directly influences how judges perceive parental fitness. That means your ability to stay calm, especially when provoked, can literally determine how much time you get with your kids. Now here's where most people go wrong: they think they can vent privately. They think their late-night texts, emotional emails, or Facebook rants are just harmless outlets. But in reality, every digital footprint becomes potential evidence. That angry text you sent in the heat of the moment. That sarcastic post about your ex. That voicemail where your voice cracks with rage. They can and often will be used in court to paint you as unstable, impulsive, or emotionally volatile. You might be 99% composed for months, but it only takes one explosion, one bad day, for everything to unravel. Judges and custody evaluators don't see that outburst as a moment of weakness. They see it as a glimpse into how you handle stress at home, around your child. So here's the strategy that emotionally intelligent parents use: they treat emotional control as part of their custody plan. Protect your peace like it's evidence, because it is. Get a therapist who understands high-conflict divorce. Join a support group of parents who've been there. Work with a custody coach who can help you rehearse how to respond calmly in court or during mediation. Even simple habits, journaling your thoughts, exercising, cutting off contact when things get heated, can make a huge difference. You're not just managing emotions, you're building credibility. When you stay centered, when you respond instead of react, you shift the entire power dynamic. Your ex might throw accusations, your lawyer might get aggressive, but the judge will see you, steady, rational, and child-focused. And that's the kind of parent courts trust. Because in the end, it's not the loudest or most emotional parent who wins. It's the one who shows the court, through calm, consistent behavior, that they can give their child what the legal system values most: stability. So remember, staying calm isn't weakness. It's strategy. It's protection. And in the battlefield of custody, it's often the difference between losing control and winning your child's future. Here's the reality most parents learn the hard way: custody agreements aren't decided by love alone. They're decided by who understands the system better. The court doesn't measure hugs, bedtime stories, or how much you've sacrificed. It measures stability, documentation, compliance, and composure. And that's where smart parents separate themselves from emotional ones. Because love without strategy can cost you everything. Let's recap what the system really rewards. Don't trust labels like joint custody. Titles mean nothing without details. Courts use words like joint and shared, but those can mean anything from full equality to minimal visitation. Always dig into the schedule, clarify the language, and make sure your rights are written, not assumed. The most heartbreaking stories come from parents who thought they had 50-50, only to discover they signed away half their time without realizing it. Document everything. You might think the judge will see your heart, but they see your evidence. Every message, every school pickup, every missed call matters. Your journal, your emails, your logs, that's your shield in court. When your ex spins a story, your records speak truth. And in family court, truth on paper beats emotion in person every single time. Follow the law, even when it hurts. It's tempting to take matters into your own hands when things feel unfair. But custody court isn't a place for rebellion, it's a game of patience. If you withhold visitation or refuse to comply, even for what feels like a justified reason, you hand your ex ammunition. The system rewards calm compliance, not righteous defiance. Protect yourself by using motions, not emotions. Protect your finances. Money doesn't just pay bills, it represents responsibility. Courts view consistent financial support as proof of stability and reliability. Even if your ex wastes the funds, even if it feels unfair, stay disciplined. Keep records of every payment. Be the parent who always meets obligations, because in the judge's eyes, that's the parent who can be trusted. Guard your emotions like evidence. Your demeanor is part of your case. The parent who keeps calm in chaos shows the court they can handle parenting after divorce. Emotional self-control isn't just maturity, it's legal strategy. Every text, every reaction, every appearance counts. Because at the end of the day, custody isn't about who loves their child more, it's about who looks more capable of providing a stable environment. And the truth? You're not powerless. You're just uninformed, until now. If this helped you see your situation more clearly, subscribe and turn on notifications. Every week, I break down the hidden traps of divorce, and how to protect yourself emotionally, legally, and financially. The system might feel rigged, but information levels the playing field. Once you understand the rules, you stop reacting, and start winning strategically. You stop fighting from emotion, and start fighting from knowledge. So if you take one thing away from this, let it be this: learn the game before you play it. Because your child's future depends not just on how much you care, but on how well you prepare. I'm not your lawyer, but I'll help you understand what most lawyers never explain. So stick around, watch this next video where I break down the 5 divorce documents you should never sign. Disclaimer. This video is for informational purposes only and does not constitute legal advice. Always consult a licensed family law attorney in your state to discuss your specific situation. Because when it comes to custody, love is your motive but knowledge is your weapon.